Hello, everyone. Thanks for checking out the show. Listen, for today, we're going to talk about the ICE raids and what the Supreme Court has done to ensure that more erosions of freedoms, more erosions of precedent and policy are going by the wayside. My name is Dr. L, and this is The Breakdown. Thank you so much for checking out this episode. We're going to dig into the Supreme Court's willingness to hear the arguments about racial profiling, particularly in LA, when it concerns immigrants, ICE raids, etc., stops and frisks and all this type of stuff. And unfortunately, we can't have a conversation in this country. We cannot have a conversation in this country without speaking about addressing the elephant in the room, and that is race. In this particular context, we're going to talk about those from the Latin community, Latinx, Hispanic community, and their possibility of being stopped and profiled along the way, whether going to work or driving or whatever. And I'm always concerned about the slippery slope. I'm always concerned about the slippery slope and all that. So we're going to start this off with a quick video here to try to address who gets targeted by the police. And I'm concerning ICE, ATF, state police, whoever gets targeted. We're going to listen to a video that I found on Instagram. I'm assuming it's accurate and true. So we'll play this and we'll see how it goes here.
Parties have no one to call if they're wrongly arrested. The white person will call their local political committee man or person. They'll call the parents, perhaps, of a teenager, will call the local politician. Yo, what's going on here? My child was arrested just because he didn't have his license. Why didn't you just tell him to go home and get his license? And things like, so the white person has more power. Black people have no connection to people in power. So there's not going to be any blowback on arresting a minority because they don't have any power to complain.
And Afro-Americans are not only unjustly arrested, they are not treated with the same respect as white people are.
I ran because nobody else ran again? Or if you stop somebody from going through a light, you would say, hey, out of your car. Out of your car. Show me ID. You wouldn't say that. To a white person, you would go up and say, may I see your driver's license, please? And blacks know that. Blacks know when you go, hey, out of your car, now. And then they say, well, what did I do? Oh, what did I do? Don't say that. Don't ask me why I'm stopping you. I said, get out of the car. And that's right there, your first disrespect. And I saw that happening, and blacks know it's happening. They know it's not happening to white people. So automatically they start resenting the police just from little verbal commands, let alone the physicality of grabbing somebody and putting them in handcuffs while you check their ID. Unfortunately, when I would tell other officers, whoa, that's enough, then they would think, hey, what are you? N for the word. What are you, an N lover? N? And N for Nigger. Parties have no one to.
So this is about power. This particular officer is speaking about power and the connection to it and the lack of those who have it, or those who have it having lack of access to power, and things that he heard on his time on the PD. This is from Instagram. I'm assuming that it's true and accurate, hasn't been AI'd and all that kind of stuff when we put that particular thing out there. So also I teach ethics. I'm teaching in the ethics class right now, how police should conduct themselves. I'm also teaching at the same time a class about race, ethnicity in crime, race, ethnicity in America. I think that's the name of how it goes. So I'm teaching a couple of classes like this. And of course, I'm going to address these types of things, probably make this video that I'm going to do right now, some watching and viewing material. But I wanted to speak about this because this is important, because who are we targeting? Who are ICE raids and ICE personnel, immigration, customs enforcement, who are they going to be targeting in this time? So this is essential. This is important that we understand this so we can have a better understanding about what's going on and why these people get targeted. So again, what I did was I let me remove this here. Stop screen share, present, share screen, Supreme Court cases. All right. So what I did was I just did a brief AI search of Supreme Court cases that involve race and police. Right. We got Washington v. Davis. This landmark case established that to prove a violation of the Equal Protection Clause, plaintiffs must show a discriminatory intent on the part of the government, not just a desperate racial impact from a policy, right? So they got to show that there was some type of intention when they did this, discriminatory intent, not that it just happened to affect Black people or happened to affect Hispanic folks, right? Then we got Baston v. Kennedy, 1986. The court held that the use of race to exclude potential jurors during jury selection criminal case violates the 6th and 14th Amendments. Graham versus Connor, Brown versus City of Onyeta. While a Supreme Court decision itself, while not a Supreme Court decision itself, this case is a key example of legal challenges to racial discriminatory practices by police officers during stop and questioning, bringing up the constitutional limits of law enforcement. Dred Scott decision was a long time ago. Strauder versus West Virginia, Plessy v. Ferguson, 1896. That's what it popped up with, but it did not mention. It did not mention. It did mention what is that? Graham versus Connor, and what the law enforcement in this country, and you'll know this if you have any kind of training in this, right? Criminal justice. You take some basic criminal justice classes in this. You'll understand that Graham versus Connor was really in many of the primary laws when we talk about use of force cases. Terry versus Ohio, who can be stopped and frisked. Graham versus Connor. Tennessee versus Garner, right? Graham versus Garner is how many, all these incidents, those 3 incidents included the stopping, frisking, and use of force against Black folks in particular, right? Of course, when it was written about a general, how should we treat all American citizens? But this was the impetus of this, right? Even the Miranda decision who was a Mexican American, I believe, but he was certainly of Mexican descent. The Miranda decision, right? You have the right to remain silent, this, that, and the other, right? Questioning people and they had to establish these types of precedents. They, being the Supreme Court, had to establish these types of precedents because all minorities were not being treated the same, right? As the officer was making a claim from his time in the Philly PD, this is how we treated people. We knew who to talk to in a certain way, and we knew who not to talk to in a certain way. Terry versus Ohio, who do we stop? Whose pockets do we touch and go through, and all that? Who do we do that to? Are we doing that to white folks? Jeez. Are we doing that are we doing it to people who have deliberately been robbed of their power, of their political power, and do not have connections to call someone, right? This is who we're doing this to. So let me put this on the screen here, right, before we get into to the meat of this, right? So this comes from the Fordham Urban Law Journal. Fordham Urban Law Journal, right? This abstract says this article argues that in formulating standards for stop and frisks, courts, police departments, and other policymakers should consider whether and to what extent Blacks are more frequently stopped and frisked than whites, whether to and what extent this disparity reflects racial bias, and the nature and extent of the results and negative effects. Again, so, they're asking them to go against the previous case that I talked about, right? The article provides an overview of the discussion of U.S. v. Terry and its impact on subsequent case law. It focuses on Terry's ambivalent position on race relations and posits that empirical contention about the law's inevitable efficacy against racist abuse on the stop and frisk power is grounded in an unrealistic model of police motivation. Right? This article argues that racial impact should be taken into account in both the legal and administrative delimitation of the stop and frisk power. In other words, what he's saying is you got to consider race and its impact. I know we don't want to think about race in this country. I know we want to treat everyone equally. We know, according to the other case law that I read, it's not about the disparate impacts, but it's about the racial intent. There is no racial intent, right? We're stopping people based on what is going on, who is being stopped, and whether they are being stopped and frisked for, their time, their location. Are there any reasonable or articulable statements that we can make, instances, facts that we can make in order to stop this individual in their journey and stop them and then frisk them, which is a cursory pat down just to check for weapons to make sure that this person is armed, could be armed, right? Police just can't stop and frisk people. They have to have a reasonable, articulable suspicion that this person may be armed. You can stop someone, but you can't just touch them and frisk them. You have to do that. Now, all this type of stuff, Miranda decisions, Terry decision, Garner, Graham, all these decisions were based on the overthrowing some of the things that were in the past, the Dred Scott decision, Plessy versus Ferguson, that the black codes, etc. All these different codes, laws, court decisions all said that black folks in particular had no rights that white people uh, had to respect, and therefore could be corralled, therefore could be targeted, therefore could be prosecuted in all this, right? So this was an attempt by the courts to go against or to go against the de facto law of the land. So this is the issue that we're still having today, and this is what this article is talking about. Who is being stopped more? Who is being frisked more? Who is the real targets when they drive into certain locations, when they walk into certain locations, because of their presence just in the community? Are they being disparately frisked, stopped, etc.? So this is what this article is attempting to talk about. Just take away their guns, right? The hidden racism of Terry versus Ohio, and what this again was speaking about is who is being stopped, why are they being stopped, and should these people really have guns, right? Who has the right to bear arms? I talked about this in another episode. Go back and read it. Go back and review that when I talked about the Second Amendment. Who really has the right to carry guns, right? Because if we live in this particular if we live in this country where the Second Amendment is what it is, then why are we frisking people if they have the right to have guns? Well, it really was about who has the right to bear arms, right? I hope that all makes sense. Let's go on to the next thing here. Yeah, let's go on to the next thing here. Rethinking high. Let me put this on the screen here. Stop screen share. Screen share. I think it's this one here. Yeah. All right, so this one is Rethinking Hindsight, the Failed Interpretation of Graham v. Connor by Alec. Gosh, I can't even say the guy's name. Let me see if I can make this larger here. It might be too big. Let's see. All right. Let's see. All right, Rethinking Hindsight, Alec Sogohamanian. Jeez. And this comes from the NYU review, New York University Review of Law and Social Change. Introduction. Police violence is an epidemic in the United States. In 2021 calendar year, 1,005 civilians were shot and killed by police. One might expect the myriad of social distancing and stay-at-home regulations promulgated during the COVID-19 pandemic to bring a reduction to the number of police shootings. And this goes on and on about this. It talks about how many folks were killed, unfortunately, and this deals with the Graham v. Connor decision. So I think it's worth understanding, worth reading, that blacks are often in these cases, right? The development of excessive force standards, right? They're never going to say it outright. They're dancing around this, but these are the decisions, right? Edward Garner is a 15-year-old black male. Why was this 15-year-old black male who was running away in the Tennessee versus Garner decision? Why was this man shot in the back? Would they have shot a 15-year-old white boy in the back? Right? Would they have done that? Would they have done that? Right? So these are things I want you to consider as we go through this type of thing. Who has the power? Who has the power? This comes from the Latin X Resource Guide, Civil Rights Cases and Events in the United States, Library of Congress. This was the Miranda versus Arizona decision, right? Again, Ernesto Miranda charges of rape and kidnapping. Was identified. He had 2-hour interrogation. Police did not advise Miranda of his constitutional rights to attorney and self-incrimination. Nevertheless, he signed a consent form acknowledging and admitting confession, committing to the crime. You can't hold these people for extended periods of time without advising them that they don't have to answer questions, that they have the right to a lawyer, right? Again, taking advantage of people who don't have power, right? So you have to advise them, right? This is what we're talking about here for today. You have to advise them. Okay, so we're going to get into the meat of what I wanted to discuss today. And so we looked at power, we looked at those who are vulnerable, we looked at some different case laws, and I'm just giving you a brief summary of these different types of case laws. You can go over there, read them in more fuller context a little bit later. Now, I'm going to get into some stuff here that I'm hoping will make sense. And of course, I've never been to law school. I'm just a guy was formerly a police officer, and I'm very concerned about the slippery slope that we're on. So if there are anyone who has a greater understanding of these case laws, feel free to chime in, and feel free to correct me if I make anything that's wrong. Right. So I'm going over here to the SCOTUS blog. Right. So the Supreme Court allows federal officers to more freely make immigration stops in LA. Let's read through this a little bit here. The Supreme Court on Monday paused, and there's a little link here, a ruling by a federal judge in Los Angeles that imposed restrictions on the ability of federal agents to make immigration stops that a plaintiffs say are based on racial profiling. This one sentence here. So what is this first sentence trying to tell us, right? So a federal judge, so the way the court cases go, people will sue in different cases, right? And sue or get arrested or whatever, and they make appeals up the ladder all the way up to the Supreme Court, which is the highest law of the land. And whatever they say goes. There's no one else to appeal to. Their word is the law. Their word is final, etc. Right? But what happened was a federal judge in a lower court impose restrictions on the ability of federal agents, those will be the ICE agents, to make immigration stops based on racial profiling. So officers, ICE agents were going up to people, stopping them at different farms, Home Depots, etc., and just stopping them based on their ethnicity, the color of their skin. Maybe they heard them speaking broken English, or heard them speaking Spanish, and just said, "Hey, we're going to stop you. We're going to make you provide proof that you are who you say you are, and you are an American citizen, and that you belong here." So that lower court judge said you can't do that. But the higher court, the Supreme Court, said, "Hey, you know what? We're going to allow you to continue to do that. We're going to pause what you said, and we're going to take a further look in this," right? And it should be, based on the court cases that I tried to lay out for you, that this should be well known that you can't just do this based on their race. Remember, we talked about Terry v. Ohio. You got to have reasonable, articulable suspicion. This is well entrenched, well understood in policing and law enforcement world. And now the Supreme Court says, whoa, wait a minute. We're going to take another look at this. Wait a minute. So again, I'm worried about a slippery slope. It's immigrants today. It could be you tomorrow in Montana, in Idaho, in Connecticut, in Florida, in Massachusetts. It could be you in Oklahoma. It could be you tomorrow. So this is what I'm worried about, right? If they pause that, why can't they pause other things, right? The order by U.S. District Judge Mame Esau Mensah Frimpong barred agents in the Central District of California, an area with a population of about 20 million people, from making such stops without reasonable suspicion that the person being stopped is in the United States illegally. Reasonable suspicion, Frimpong added, cannot rest solely on a combination of four factors: apparent race or ethnicity, speaking in Spanish or accented English, being present at a location where undocumented immigrants are known to gather. That's been well established too by court cases, right? You can't just stop young Black kids, young Hispanic kids, young white kids, and think just because they're gang members. You got to have something. You got to have some other type of rationale that you can articulate, that you can point out, that you can write down on a piece of paper and say, this person was doing this. This is what made me think that. Not just because they're in a location at a bad time. You have to have some type of predictive or some type of articulable suspicion as to why you're stopping them. This is well known within case law, right? And I'm sure that this is what this judge Frimpong was basing her ideas on. Reasonable suspicion, Frimpong added, cannot rest solely on these items that I mentioned are known to gather, such as pickup spots for day laborers and working at specific jobs such as landscaping or construction. Right? This is stereotyping people. Monday's order by the Supreme Court put Frimpong's ruling on hold while the Trump administration's appeals to continue. In an opinion agreeing with the decision to grant the government's request for a stay, Judge Brett Kavanaugh emphasized what he characterized as a narrow role of judges in immigration cases. Judges, he wrote, may have views on which policy approach is better or fairer, but judges are not appointed to make those policy calls. We merely ensure, he stressed, that the executive branch acts within the confines of constitutional and federal statutes. We've got the precedent for the Constitution, the laws I've already laid out: Miranda decision, Tennessee versus Garner, Graham versus Graham versus Connor. We we we've got this. Terry v. Ohio about stops. We've got all this. This has been laid out already, and in those cases we all dealt with race in all of them. Justice Sonia Sotomayor dissented from Monday's ruling in a 21-page opinion joined by Justices Elena Kagan and Kajani Brown Jackson. They're going to continue to be outnumbered all the time. Sotomayor described the court's action as yet another grave misuse of our emergency docket. We should not have to live in a country where, she wrote, where the government can seize anyone who looks Latino, speaks Spanish, or appears to work a low-wage job. Rather than stand idly by while our constitutional freedoms are lost, she concluded, I dissent. I'm in agreement with you. I don't think that that's right. The case stems from a federal immigration raid that began in LA area in June as part of what the government officials have called the largest mass deportation operation in U.S. history, describing the government's actions as creating an illegal detention and deportation dragnet, a group that includes both U.S. citizens and undocumented immigrants who had been targeted by the raids who went to federal courts the following month. They contended, among other things, that the raids violated the Fourth Amendment's ban on reasonable searches and seizures, which the government has generally prohibits immigration officials from stopping someone in public unless they have reasonable suspicion that that person has violated federal or immigration law, right? You got to have something, you got to be able to point to something and say, this person did X, and that's why I'm stopping them. That reasonable suspicion the challengers contended in their complaint must be based on specific articulable facts rather than broad profiles which cast suspicion on entire categories of people. Again, I'm saying we addressed this. While they didn't address it specifically, that was and that was the point of the article that I read from the Fordham law blog. They gotta do a better job with that. You got to address it specifically, because as long as it's not, the outcomes, as long as it's not the outcomes, but it's specific intent. The problem is that we know this is going on, but unless somebody says, I'm stopping you because you're Latino, I'm stopping you because you're Black, I'm stopping you because you're a woman, I'm stopping you because of this, what officer is going to say that? Frimpong issued an order on July 11th that prohibited government agents from making immigration stops unless they had reasonable suspicion from the person they were stopping was an undocumented immigrant, and from relying on or any of the four factors on the basis of reasonable suspicion. After the courts of U.S. appeals for the Ninth Circuit largely left Frimpong's order in place while litigation continued, U.S. Solicitor General John Sauer came to the Supreme Court on August 7th asking the justices to step in. Went over her head. I don't like this decision. Sauer contended that the order puts a straitjacket on law enforcement efforts. How are we going to get this job done if we can't go around targeting those of Latino descent? How can we get the job done? And in any event, he added the challengers lack a legal right to sue, known as standing, because they do not have any reason to believe that they will be stopped by federal immigrants in the future. Oh, we're only going to stop Latinos. So you got to be a Latino to bring this this lawsuit. This is crazy. This is crazy what they're saying here. Lawyers for the challengers pushed back, telling the justices on August 12th that if they did not have the right to sue, the government could send out roving groups of agents every night to engage in raids all over any city, involving the most blatantly unconstitutional invasions of law-abiding individuals' privacy imaginable. And it would be impossible to enjoin that behavior because no plaintiff could definitively prove that he would be caught up in a future raid that would, like the ones before it, violate the Constitution. I agree with that assessment. They also stressed that Frimpong's order was only a temporary one, which the justices would likely never have a chance to review on the merits. In the concurrence, Kavanaugh explained that the Trump administration had met both of the most critical factors that the court considers in deciding whether to grant temporary relief. First, he explained, given the significance of the issue of the government's immigration enforcement efforts. Now, given the significance, this is Judge Kavanaugh who wrote this opinion. We're going to read from that in a little bit. Now, remember what he said first First, what he said was, or at least what they recorded him as saying, Judge Kavanaugh, Judge Kavanaugh emphasized what he characterized the narrow judges' immigration. Judges, he wrote, may have views on which policy approach is better and fairer. This is an opinion, but judges are appointed to make those, are not appointed to make those policy calls. We must ensure, he stressed, that the executive branch acts within the confines of law and federal statutes. Remember, that's what this judge said previously, right? Or at least previously recorded here. Now, he explained in the concurrence, Kavanaugh explained that the Trump administration had both met the critical factors that the court most critical factor the court considers in deciding whether to grant temporary relief. First, he explained, given the significance of the government's enforcement issues, so he should not be relying on his opinion about whether this is moral, right, or I agree with mass deportation, right? This is why they're always asked when they do these confirmation hearings for these individuals, you know, what is your personal policies, personal law, personal morals? What do you really think, right? This is why they asked him this, because you got to do what Kavanaugh said he's supposed to do, and just based on the Constitution. The Supreme Court would likely to grant review if the Ninth Circuit were to uphold Frempong's injunction. Second, Kavanaugh continued, the Trump administration has shown not only that the Supreme Court would likely grant a review, but also that it would be likely to reverse the lower court's ruling in the challenger's favor. The challengers likely lack a legal right to sue known as standing, Kavanaugh wrote, because although they may have been stopped in the past, they have no good basis to believe that law enforcement will unlawfully stop them in the future based on prohibitive factors in Frempong's injunction. That is crazy. That is crazy. They're out there targeting black men. Well, first, if you're a white guy, you say, "Oh, listen, I'm going to sue on the behalf of these black men." Well, you don't have any standing to sue because you're not likely not going to get stopped because you're not a black man. Okay, well now you're a black woman, you're going to do it. Well, they're only stopping black men, but because you are a woman, you don't get to sue. That's what they're saying. That's what this guy is saying. Oh, and even if he did, right? Okay, let's just say that they're stopping all Latino men and you're a Latino man. Well, you still might not get caught up because maybe you're not at that location, right? You drive a nice car. You're not at a Home Depot. You're not on a farm. You're not speaking broken English. What are we saying? Or you just won't get stopped, period. No, how do you know you're going to get? How do you know you're going to get stopped? How do you know that? Come on. Is this what we're saying here? Moreover, Kavanaugh added, although apparent ethnicity alone cannot furnish reasonable suspicion for an immigration stop, reasonable suspicion can rest on the totality of circumstances. Here he stressed circumstances such as the extremely high number of percentage of illegal immigrants in the LA area. The fact that the undocumented immigrants often gather in certain locations to seek daily work and often work in certain kinds of jobs, such as day labor, landscaping, agriculture, and construction, and that many of these illegally in the LA area come from Mexico or Central America and do not speak much English can, when taken together, constitute at least a reasonable suspicion of illegal presence in the United States. Wow. And again, I'm worried about a slippery slope. I am worried about a slippery slope. Okay, well, somebody will be able to quote this and say, well, okay, well, all black males are just gather on the street corners. All white males who are up to no good, take up residences in Idaho on farms out there, and they want to, they're plotting terrorist attacks. Is that a possibility that could happen? Should we go in there and raid those people? Right? In her dissent, Sotomayor argued that the Trump administration, and now the concurrence by Kavanaugh, has all but declared that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to the agent's satisfaction. In Sotomayor's view, the Trump administration had not shown that it was ultimately likely to prevail on the merits. In particular, she wrote, a set of facts cannot constitute reasonable suspicion if it describes a very large category of presumably innocent people. Allowing the seizure, she said, of any Latino speaking Spanish at a car wash in LA tramples the constitutional requirement that officers must have a particularized and objective basis for suspecting a particular person is stopped of criminal activity. In some cases, the there was a predictive measure that we needed as police officers to stop someone. Somebody calls the police and gives an anonymous tip and says, "Hey, you know what? I know that this guy wearing a blue cap and a blue shirt, he's going to be at 2 o'clock in the afternoon. He's going to be standing in this corner. And he's going to have drugs in his pocket. And there's a white car that's going to pull up, and then they're going to do a hand to hand. And then the white guy in the blue cap is going to get into his car, which is a gray sedan, and then he's going to drive. Then he's going to drive away." That is predictive information, very specific, right? And it targets a crime, hand-to-hand drug deal. And so that based on that, then you can stop the person who drove away, and then you can stop the guy in the blue hat who's in a sedan, right? That's what you can do because it's predictive. You're just going up to people in this particular instance, and they're saying that being here illegally. I get that there's a sort of crime that's got to be, but what predictive model is there? They are working, and now they're speaking Spanish, and then you're going to stop them and seize them and detain them. I mean, what if they don't have their ID on them? What if they're so nervous that they just can't, their English gets even more broken because they know what could happen, right? Everybody's seen not only the stops and the taking away, but sometimes the violence that could go if they resist or if they're not moving fast enough. All this is essential in all this. All right, we're gonna finish this off with can I get this out of here? Why is this over here? I don't want that on here. Anyway, we're going to finish this off here with what the Justice Kavanaugh actually wrote and said, right? This is Supreme Court of the United States, number 25A169, Christy Nome, Secretary of the Department of Homeland Security, et al. Versus Pedro Vasquez Perdomo, et al. On application for stay, right? We get to Justice Kavanaugh, who we quoted before. Concurring in the grant of application to stay, I vote to grant the government's application for an interim stay pending the appeal of the district court's injunction. The Immigration and Nationality Act authorizes immigration officers to interrogate any alien or person believed to be an alien as is his right to be or remain in the United States. Gives the statute numbers, U.S. Code. Immigration officers may briefly detain an individual for questioning if they have reasonable suspicion based on articulable facts that the person being questioned is an alien illegally in the United States. More section numbers, U.S. Other case numbers, and all this. The reasonable suspicion inquiries turn on the totality of circumstances. The government estimates that at least 15 million people are in the United States illegally. Many millions illegally enter or illegally overstayed just in the last few years. Illegal immigration is especially pronounced in the LA area. Among other locales in the United States, about 10% of the people in LA regions are illegally in the United States, meaning about 2 million illegal immigrants out of the total population of 20 million. Not surprisingly, given the extraordinary numbers U.S. immigrant officers have prioritized immigration enforcement in the LA area, the government sometimes makes brief investigative stops to check the immigration status of those who gather in locations where people are hired to work for days, who work or wear or appear to work in such jobs as construction, landscaping, agriculture, car washes that often do not require paperwork and are therefore attractive to illegal immigrants and who do not speak much, if any, English. If the officers learn that the individual they stopped is a U.S. citizen or otherwise lawful in the United States, they promptly let the individual go. If the individual is legally in the United States, officers may arrest the individual and initiate the process. Immigration stops based on reasonable suspicion of illegal presence have been an important component of U.S. immigration enforcement for decades across several presidential administrations. In this case, however, the district court enjoined U.S. Immigrant officers from making investigative stops in the LA area when the stops are based on the following factors or combination: presence at a particular location, such as a bus stop, car washes, day labor pickups, agricultural sites, and the like. 2, the type of work one does. Speaking English is the 3rd. And apparent race and ethnicity. This is what the previous judge said. No, you can't just do that based on these things. So this court is now saying, nah, pump the brakes there. We think it's okay to do that. The government contends that the conjunction will substantially hamper its efforts to enforce the immigration laws in LA. The government has therefore asked the courts to stay the court's jurisdiction. To obtain a stay from this court, the moving party must demonstrate a fair prospect that if the district court's decision were affirmed on appeal, this court would grant certiorari or reverse. The moving party also must show a likelihood that it would suffer irreparable harm if a stay were not granted. In other words, you got to prove that you're going to be hurt by this. You had to be proved that. Those 2 factors are the most critical, particularly in close cases. The court also considers the balance of harm, equities, etc., including the public interest. In my view, the government has made sufficient showing to obtain a stay pending appeal, so they're going to hear this case, right? The brakes have been pumped. To begin with, the significance of the issue to the court's government enforcement, this court would likely grant certiorari if the court appeals affirmed. In addition, on 2 other alternative grounds, the government demonstrated a fair prospect of reversal. So they're already anticipating they're going to reverse that. Already anticipating they're going to reverse it. So again, I'm not a lawyer. I do ask lawyers to come on this channel to kind of talk about it, break it down a little bit. I can't get anyone to come on. So listen, you guys, I'm worried about a slippery slope and what that means for law enforcement. Also, when I teach these classes, when I teach policing in the community, etc., I talk about the cooperation. I talk about what cooperation means from the public community going to giving out information to the police. And when you do things, when the government, to quote Kavanaugh here, when the government does things, says things, and allows things that we consider to be kind of rough, not in line with, let me put this up here, subscribe, share, and hit the like button. When they do those types of things, it erodes public trust within the by the community towards the police. And if the police want community interactions, they want to be able to solve crimes. They want to work with the community because as one, the founder of Sir Robert Peel of modern day policing said, the police are the public and the public are the police. If you want these people to become police officers, to engage with the police, to work with the police, then you have to create the type of environment in which they would feel comfortable enough to do so. And again, I'm worried about a slippery slope. If this goes through and they can stop these people in LA, then they'll go to Chicago, they'll go to New York, they'll go to Miami, they'll go to Dallas, they'll go to Arizona, they'll go all these different places doing the same thing. And then next thing you know, they'll be stopping other people on street corners or in alleys, in trailer parks, stopping those who, what was the first video I played, who don't have power. So I'm worried about the blowback that this could cause. I'm worried from the community. I'm worried about how this is going to look towards other communities, particularly those who don't have power, and also looking to make sure that the police get the support and people want to become police officers. They don't want to become part of a negative Gestapo organization that is going to hurt people. Right? I don't think that most people are signing up for that. But let me know your thoughts and your opinions. Hit me in the comment section. Do you agree with the Kavanaugh's decision to stay, and of course all the justices agreed upon this, or do you agree with Sotomayor? Do you agree that people with power often are targeted by police, and do you agree about a potential for a slippery slope into more people of all the different ethnicities and groups being targeted up and rounded up? And I just see this as an erosion. I just see this as a slow erosion. So let me know your thoughts and your opinions. Hit me in the comment section. Until next time, much love and peace.